Hey there, welcome to this episode of the Legal Paige podcast. Today, I am going to do a legal Q&A from questions that have been submitted over the past couple of months in the Legal Paige community Facebook group. If you are not a part of the Facebook group and you are a small business owner, I highly suggest that you join. We have thousands of phenomenal small business owners in there that are asking questions and helping each other and giving feedback and advice. And me and my legal team are actually in the Legal Paige community Facebook group monitoring questions. And it is one of the only places I can actually answer your questions because it's in a group forum setting. So, we don't have to worry about attorney-client privilege attaching or anything like that because it's not confidential. You're asking it in a very public space. So these questions I thought were really pertinent to a lot of different business owners. And I thought it would be best to kind of come on here and give my 2 cents and take on these questions. Of course, I always answer them in the actual posts and I do responses to people's posts, but I just thought it would be a fruitful discussion to kind of continue the conversation on here in this episode. So without further ado, let's just get to it, shall we? You're listening to the Legal Paige podcast, where we chat about life and business with a legal twist. I'm Paige, attorney and photographer helping online businesses and creatives tackle their business dreams without breaking out in hives. No more legal mumbo jumbo. This podcast features simple, bite-sized advice that'll have you legally legit in no time. Are you ready? Let's get started. As a reminder, before we get into this episode, I am legally obligated to give my disclaimer. So I am an attorney, but I am not your attorney. All legal information I talk about on this episode is intended for the masses and a large variety of different businesses. I am only your attorney when you hire me and we sign an engagement letter for me to work specifically on your legal issues. Please feel free to seek out another attorney in your hometown if you need specific legal advice or contact me for more information. Alrighty, here's the episode, friends. Alrighty, so as we jump into this episode, I am going to break it up into kind of a few big categories. The first one is surrounding kind of contract clauses and contractual situations and questions that people had. The next, I am going to get into COVID and vaccinations primarily. So now that the United States is primarily vaccinated in many, many different states, and we're reaching herd immunity in various areas of the country, there's a lot of questions surrounding vaccinations and who you can ask and so on and so forth. So we're going to get into that. And then we are going to go into kind of business structure and insurance questions. So first, let's start with the first question that was submitted regarding contracts and contract clause questions. If I am shooting a family who signs a model release form, does it have to include all family members and who signs it? Okay, great question. So yes, if you have any type of photography contract, there's usually a model release clause in the contract, and that's really important. So TLP template contracts, our family photography contract, our engagement session contract, newborn session contract, any type of portrait photography that you could think of where there's probably going to be minors present, you are likely only going to have one family member sign who can legally do so on behalf of the minors present. And then people do always ask, do you need both parents to sign? There's really only one situation where you would need that to occur, and that's when you have multiple families, like a large group of family members. But I'll get into that. So first and foremost, if you are just shooting, say, like a family who has, let's do a mom and a mom, and then they have 3 kids with them. So I would just do the contract between you and one of the moms who is booking with you, and they will sign on behalf of the entire family, and you'll just want to list out the other mother present and then also all of the children present and their names and their ages. And then the model release clause in your portrait contract, so your family photo shoot contract you're sending out, should include the model release clause. And in your contract, contract, you just want to make sure that you're listing who will be present. And then when they sign the contract, they are signing on to the model release as well. So both parents don't really have to sign there. That's totally fine as long as they're listed. If you are concerned at all, the only other situation I can think of that really involves multiple model release forms is when you do a large group family shoot. So say you have like 20 to 30 family members and you have 5 to 8 individual family units. That's when I would do the actual like portrait contract between you and just the family member who's setting it up with you. Cause there's usually always one that's like, poly planner, like wants to help out the family and get this all scheduled. And then you would make sure that you bring a model release form with you, most likely is going to be the easiest way to go about this. I know it's old school. You can probably send out the link to this, poly planner who's the one that's signing your original contract. And then you ask them on behalf of you to send out this link to all the family units to sign. That just seems a little cumbersome. And honestly, that's like putting your onus and your liability and risk regarding model releases on that one person of the family versus you just bringing like a 1-page model release form with you and having one of the parents sign in every single family unit and just having them list out their kids. And then you can also like have little check boxes in your model release form, and each parent and family unit can decide like, are you okay with sharing these photos on my social media and on my website? Are you okay with me sharing photos of your kids? And everyone might have different feelings surrounding that. So I just usually bring the forms with me. I think that's the best way to go about this. And they will probably really honestly respect that you are taking the initiative to ask them what their preference is. So that was a great question. The next question I have is in regards to force majeure. So these are act of God clauses. I don't call them just act of God clauses because an act of God is kind of underneath a force majeure situation. And so within TLP template contracts, we label our clauses as force majeure, which means of superior strength. And if something were to happen of superior strength, then what would that event look like? And it's listed out in the clause. So an act of God is technically considered a force majeure event. However, with COVID and everything that has happened over the past year, it gets complicated for people to interpret what an act of God actually is. So I think it's better to expressly delineate additional force majeure events. We, of course, delineate things such as wildfires, avalanches, hurricanes, things that could interrupt the performance under the contract, as well as riots or terrorist strikes or war or anything along those lines. So it's really important for you to add in any type of force majeure event that you want to have expressly delineated in your contract. And you can include wildfires in there, especially if you're in a highly prevalent zone of wildfires. So I am in Montana, and definitely the whole northwest side of the country is very much implicated by wildfire. So I would say if you are a service provider that does work outside and some of your services could potentially be impacted by things like wildfires or avalanches if you're shooting or performing services during the winter time as well. Those are all things that I make sure to have listed in force majeure clauses in this area of the country. Of course, we're not implicated by hurricanes per se or tornadoes. And so if you're, of course, on the East Coast, a little bit more down south, implicated by those type of natural disaster type of situations, then you definitely want to list those out in your contract. Here is kind of what came up in the Legal Paige Community Facebook group. So we've had lots of discussions on wildfires in terms of what happened last year. 2020 was a doozy, I tell you. Especially for the wedding and event industry, elopement industry, photography industry. And you know that a lot of TLP followers are kind of within that realm and niche of business. And wildfires were very prevalent. It's like we all went through COVIDity and then we had to like deal with wildfires basically shutting down everything for the end of the summer. And it was just tragic for lots of people trying to get married and have elopements and things like that. So the wildfires The thing with force majeure that people need to be careful about is a wildfire would technically only count as a force majeure event if it did make it absolutely impossible to perform services. For example, if you were going to shoot, say, I'm near Glacier National Park, so I always like using it as an example. Glacier National Park is sometimes implicated by wildfires, and the impact of that can lead to closures of the entire park or closures of areas of the park. If you were not able to get into Glacier National Park because it was completely shut down by wildfires, then yes, that equals a force majeure situation. It has to be impossible. It has to be unpredictable. Of course, you can think that wildfires could show up, but it's unpredictable when it's actually going to happen. And there has to be no alternative means for you performing. So while you could say, oh, well, we could just shoot in the Flathead Valley or somewhere around Glacier National Park, that's probably not what your clients signed up for. Your clients probably wanted to shoot their elopement photography in Glacier National Park, and now it's closed down. So really that makes the impracticability and impossibility very, very clear under your contract. So that's when a wildfire would be force majeure. But last year, what happened, and I think this is probably we're going to see this for decades, right? Like wildfires are a very common annual occurrence. And wildfires can have obvious impacts on air quality. And so the question that came up in our Facebook group was really interesting to the fact of, well, it didn't make it impossible. We could still go to this location because they were shutting down different zones of the wildfire. And of course, having displacements of people in their homes and things like that. But that zone had not obviously been completely shut down yet, where they were originally going to have their elopement photography per se in the mountains, right? That a wildfire would be at. So the wildfire was nearby, but the air quality was horrendous. And so where does a photographer have the ability to say, okay, this isn't a force majeure situation, but it's a very unsafe working environment. And also you are not going to get the quality of photos that you would originally anticipate under the contract that we signed and the location that I scouted, so on and so forth. You're going to have basically ash in your background, and it's going to, wildfires basically make it the visibility as well as the air quality is impacted. So does a photographer have the ability to cancel a contract in that situation? You need to make sure you also have what's called a safe working environment clause here, because technically force majeure doesn't apply. And I could probably argue that all day long in court. And I bet a court as well is going to interpret force majeure as those kind of die-hard impossibility situations. So if you can still shoot in the area and technically you could perform your services without issue, even though the air quality is low, it's people's choice to go out in those conditions, right? But you could have the conversation with your clients that you are going to make kind of the unilateral decision that you're not going to be impacted by this poor of air quality. It's a health risk. It's a health risk to you and them. Also, you just never know when a wildfire could change, and you don't want to plan for something and then day of have to completely change course or cancel, God forbid. So you could proactively kind of cancel pursuant to your safe working environment clause. And I'm not going to go into too much more depth on what these clauses involve. But of course, it usually says you as the service provider have the ability to cancel, postpone, reschedule, terminate day of any type of unsafe working environment situation. You can terminate your contract pursuant to that unsafe working environment. Lots of times people include guns in these clauses. If there's any illegal activities, anything that clients could potentially do, which you guys, I have lots of back end stories regarding that would make you feel unsafe and you not wanting to perform services, you should have the ability to cut ties immediately, terminate, walk out without any further liability. So you can include things like wildfires and be very specific, when would you make that determination? Would it be within a week of the date of services that if it's impacted by wildfires, you can unilaterally decide to postpone services? You just want to make sure that you're being as clear as possible in that clause surrounding what would happen in X type of scenario. All right, the next question. When a bride cancels a wedding, I usually send out a cancellation contract. But Paige, should I also be sending out a cancellation contract to my second shooter? Or is an email to my second shooter sufficient? Great question. Okay. So because usually there isn't like a large amount of monetary impact with second shooter agreements, you can really do it either or. So a cancellation contract or a termination contract, you guys, with any type of client who's canceling a wedding is absolutely imperative because you've probably got thousands of dollars on the line. You are blocking out a date in your calendar. You have a lot riding on that contract, and it's important to send legitimate professional closure to that in terms of a legally binding termination contract. And you list out kind of what the termination of that contract looks like. And you have it in writing. Both parties, all parties are signing onto the termination of your original agreement. But it doesn't have to be that intense for a second shooter agreement. You, of course, can just send out an email to your second shooter and say, if you guys are just mutually agreeing that it's okay, that they are not going to get paid, they don't have to book out that date on their calendar anymore to be your second shooter, and all is well, and you feel very comfortable with your second shooter on doing it via email, that's totally fine. Make sure you keep documentation of it. If you're keeping contracts in the cloud or if you're keeping them in paper format, just make sure that you're kind of attaching this line of communication with your second shooter there so that you have proof and documentation that that is what actually occurred. I would say that's probably the best way to go about it if you are utilizing this second shooter often or you have a relationship with them and you feel good about just doing it as simplistic as that. If they are a new second shooter coming on board to work with you and you're just like, I just want to make this as clean cut as possible that we're not shooting this wedding. Please don't show up. I'm not going to pay you. If you want that to be as legitimate as a regular termination contract situation with a client, then yeah, send them a termination agreement. It can be a one-pager document that says we are terminating the original agreement that was signed by the parties on X date. Boom, sign. Nobody has any more performance or payment obligations under that contract. Next question, how long should I keep paper contracts? I have paper contracts dating back to 2009 as their guideline to how long we should be keeping them. This was a very, very solid question, and I think it is really important for people to understand that this not only applies to paper contracts, but online virtual contracts as well. If you're keeping a digital documentation of your contractual agreements with clients and second shooters and independent contractors, so on and so forth. So these are called record retention guidelines, and they vary per state. So it's really important you look up your state, and then I would look up breach of contract claims and the statute of limitations on breach of contract claims. So how long does someone have to potentially file a breach of contract claim under these documents that you have? Usually it's anywhere from about 3 to 5 years. I think there's a couple states that could be like 5 to 7. I would say there's probably no breach of contract claim that could go over 7 years, but I don't know. I could stand corrected here. Usually 3 to 5 years is a solid SOL, which is statute of limitations in like legal jargon acronym world. And that is where you need to kind of make your benchmark for how long you need to keep digital or paper contracts. And then for tax purposes as well, you also have to make that consideration. So usually for tax purposes, you want to keep your records for at least 3 years from the date that you filed your original tax return and or 2 years from the date that you paid the tax, whichever is later. But you also could get into a situation where your business down the road could be involved in like a security or bad debt situation, a bankruptcy situation. I mean, I'm just throwing out all of the what if scenarios as an attorney that we're thinking of when people ask us these questions, and those can be up to 7 years. So go look at your state breach of contract claim, statute of limitations. And if it's somewhere around like 5, then I would say keep all your business contracts for at least 7 years, just in case any of those other debt security, bankruptcy issues could happen with your business being implicated. So that's my answer on that one. Okay, now we're going to get into COVID vaccination bucket questions. The first question that came up was, does the COVID-19 waiver still hold as more reopenings are happening, as well as changes to CDC guidelines and executive orders? All right, so what they're talking about is there's all these kind of release and waiver forms. We had a waiver and release of liability that was heavily purchased by TLP customers last year in 2020. And really the waiver was needed when you were performing services like right away as the world opened back up. There was no vaccinations. There was like, nobody knew what was going on. I'm talking like, the beginning, middle of May 2020. We had been shut down for about 6 weeks. Many of you may be listening in other countries, but you guys know I'm in the US, so apply this to wherever you are living. So I'm just using kind of US hypos and situations here. So basically what happened is when people were performing in-person services in very close contact with another person, regardless of if you're wearing masks, it was important at that period of time to have them sign waivers and releasing liability documents. They're just like simple one-pager documents that your clients would sign. Many people did this who were in kind of the hair and beauty industry, estheticians who were fairly close contact with their clients, of course, hairdressers. I think photographers also implemented oftentimes some type of waiver situation, family photographers, engagement photographers, people who were like touching their clients or getting in close contact with their clients within kind of that 6 feet barrier. And waivers were just a good way to kind of double layer your protection in terms of risks and liabilities involved with people contracting COVID-19 at the time. But after that, I think as executive orders changed, state guidelines changed, local guidelines changed, and then of course CDC and WHO guidelines changed, it was definitely less of a worry for business owners to have these waivers being signed because it was more of an assumption of risk situation. Everyone's assuming the risk. If you're hiring this person, you're basically at that point of deciding that you're going to be in close contact with people, you've assumed the risk. And so those are the type of arguments that would be made, in court where any judge would be like, "What? You didn't even need a waiver, right?" Like every party that is going outside of their home is assuming the risk of potentially contracting this worldwide virus that is a pandemic. So now we are in 2021, and I would definitely say with herd immunity and vaccines, being disseminated all over the world and obvious mass mandates getting taken down, it's very, very clear that assumption of risk is happening. People aren't really as concerned about COVID-19 as they were before. And I would say waivers don't apply as much as they did in the past. I would still be very cautious if you were concerned about the area and potential ideal clients that you're getting near to you, if many of them could potentially be unvaccinated. I mean, you don't necessarily want to ask, but if you're concerned about those types of things and it does give you grief, maybe anxiety surrounding what if I were to contract COVID-19 or I could potentially have it and give it to people if I'm not wearing a mask nowadays when I provide services to people, then yeah, just have them sign a waiver. It's 100% okay to still use them. I would just say they're definitely not as prevalent as they were last year. Next question. Do we still use the COVID clause in our contracts for newly booked weddings, or are we past that? Absolutely use a COVID clause in your contract. COVID's not going away anytime soon. We just have vaccinations out there and some people are immunized towards the virus, but we have no idea what's going to happen in the fall and winter. I've heard lots of talk from health professionals surrounding when the virus could come back up, and there's all kinds of different variants out there, and summertime is obviously a really good time for viruses to not be as highly spreadable, but who knows what's going to happen? Are these immunizations effective forever? The research is saying probably not, only a certain period of time, but they don't have any research, so they need to wait and see. As all of that comes to fruition, what I am saying is COVID is just not gone. I think we're starting to live in this world where, things are opening back up and it's feeling back to normal, quote unquote. But we have to realize the pandemic isn't over and COVID is still a thing and people are still getting sick and having life-threatening situations. So have a COVID clause in your contract. I just want you to really think about getting rid of a rescheduling policy that allows for rescheduling due to COVID. I would just do a flat out acknowledgement of COVID clause. You are assuming the risk as the client, booking with X service provider, doing so in the middle of a pandemic. You acknowledge the risks involved, you're accepting those risks, and any changes to the contract will be pursuant to the normal rescheduling and cancellation policies under this contract kind of thing. So I would definitely make sure you have that contract clause in your contract and make sure you point that clause specifically out to your clients still. I would say at least through the rest of this year, and then you can reassess at the beginning of 2022. All right, some fun vaccination questions, which are always a little bit challenging for me to answer because I'm going to give you lawyer answers, which are usually, it depends. But how do we navigate the world of vaccinations is what someone asked. Can we ask our employees or our contractors their status on being vaccinated or not? And the question that came up in the Facebook group was really interesting. It involved a second shooter. So this photographer was shooting a destination wedding. They are vaccinated. They hired a second shooter. They were flying to this destination wedding, and the second shooter was flying with the lead photographer to this wedding. And she was assuming that this particular second shooter was not vaccinated. And her clients asked the photographer, we are having a fully vaccinated wedding and are asking all of our guests and all of our vendors to be vaccinated, or we need to make alternative plans. I'm trying to keep this wedding and event safe. So the lead photographer was vaccinated. They were under the assumption that their second shooter probably wasn't, depending on, whatever political, religious, personal views they may have, medical views they may have. I mean, I'm not going to get into that. That's people's personal choice. But this lead photographer was like, can I even legally ask my second shooter that? The answer is yes, you can definitely ask. I think you just need to decide on how do you want to come across to second shooters and what is the pros and cons of doing so. Do you think that they would prefer for you to ask them and then give them the option to either get vaccinated or not to continue working for you for this wedding? Probably that's the best way to go about this in the most professional way. This is a question on behalf of your client. So you're just relaying that question to your second shooter and then allowing them the option to perform services. I would definitely ask your second shooter first, and I think you're fine with doing that. So you can legally ask employees and contractors their status, but they can also decline to answer. So you have to be aware of that, their personal medical and health decisions, they do not have to expose to the world, and they don't have to tell you and answer. So if they decline to tell you if they're vaccinated or not, you probably have a good indication that they are not. And then you are going to have to make the appropriate next step in the process, which is contacting your client and potentially saying, I'm not comfortable asking my second shooter that question, even if you did and they said they declined to answer, maybe just say, is there an alternative way that we could approach this? Would you be okay with us doing a COVID test prior to the wedding, where if we get negative test results, then we would be fine to perform services at your wedding instead of just giving you a vaccination card. So that is a way that like countries are getting around travel restrictions, and states are allowing people to come in, like Hawaii, with COVID testing versus just a vaccination kind of passport, proof of vaccination scenario. So that's my answer on that. And then we had a follow-up question: can a venue demand vaccinated employees or workers when the contract is with our client? So I think this question was surrounding like venues saying we don't want any liability of someone contracting COVID during your wedding or event. And so we are requiring that everyone at the wedding and all people who are performing services, so the vendors at the wedding, anyone present, be vaccinated. Same thing. I think they are a private entity and they have the right to choose how they want to run their business. And they've probably talked to lawyers surrounding the ability to do so. I think it's pretty commonplace now that you can definitely ask, but you have to have alternative options for people. And you have to have kind of the ability to navigate cancellation of contracts if people aren't cooperative. So a venue could probably demand it, but then it's probably with your client. You're going to get into a sticky situation where your client's like, well, if you're not vaccinated or you're not willing to test, then the venue won't let you be my photographer. That was the scenario that came up in our Facebook group. And that gets really sticky really, really fast. So can they ask? Yes. Is there going to be lots of legal implications to that? Probably. Because your client and you have the contract, you're not contracted with the venue, but where you're performing services is now now we're in like force majeure impossibility land, where if you're not willing to get vaccinated and or have a test, then you couldn't perform your services to which your client signed on for you to do at that venue. So you probably just need to work that out. I think this is like mainly a communication error thing where people are like nervous about who they're supposed to talk to. Is this between you and your client? Is this between you and the venue? And I would say just communicate with everyone involved and see how you can manage the situation to the best of your ability as a vendor at this event. And probably there is going to be some scenario where you can perform your services, make your client happy, make the venue happy. And then finally, can a client demand that you are vaccinated and ask for proof? They can. I mean, they have the right to probably cancel the contract if you're not vaccinated and you don't give them proof. However, they're probably going to be in a scenario where it's not like a full refund situation. That's like a business saying, I'm going to open my doors. And so every person who comes in absolutely needs to show me a proof of vaccination card, or you can't be a patron at my store. That's like not legal. You can't do that right now. And so that's why you see all these TikToks and Instagrams that are making fun of like, you know, what political party and side are you on regarding vaccinations? I guess if I'm not vaccinated and I take my mask off, then like suddenly I become like a little bit more liberal because everyone's going to think I'm vaccinated. It's just like ridiculous what's going on in the world right now. So with that being said, sorry, little tangent there. They can definitely demand it. I mean, it's not like illegal for them to say, you know, are you vaccinated? I'm requiring proof of vaccinations. Again, I think they need to offer you an alternate solution just because of medical and health legalities surrounding you having the right to not disclose certain things. But if they aren't willing to budge and they only care about vaccinations and proof of vaccinations, and you're not willing to kind of work with them on that, which is fine, that's your prerogative, then you are probably looking at a cancellation of contract, and then you're probably going to have an upset client because they are basically canceling on their own volition due to their own personal feelings about having a fully vaccinated event or what have you, or they want you to only be vaccinated if they're near them. That's their own decision to do that right now. And they would be canceling pursuant to your cancellation policies. Like you would probably probably keep retainer and all fees paid. And that's how that would go down contractually with your clients. But again, you're probably going to piss off your clients even more because they asked for vaccination, you're not giving it to them, they want to cancel, and then you're like, well, you're also not getting your money back. I mean, come on. There's got to be an easier way to solve this with your clients. So really work with them, really try. But, we're still in the land of COVIDity is what I like to call it, or the vid world, where things are just going to pop up and people are still like on edge and people are still unsure how to navigate all of this. And we are too as business owners. And so just try the best you can, use your due diligence, be proactive and smart with how you are communicating and how you're interacting with clients and how you are answering their tough questions. So those are my answers on that topic. And finally, let's get to kind of business structure and insurance questions. So someone asked, when I was first opening my business, I struggled with what I needed to get, like a license or an LLC, a tax ID. I'm wondering why and if they're important to have for legal and business reasons. This question is awesome. I would first point you to a freebie that the legal page has. So we have like the 10 steps to get started as a new business owner. And it's a really simple checklist with great links to where you can go about getting your licenses, looking for licenses, getting your LLC, and then your tax ID, your EIN number through the IRS, which is free as well. Yes, you do need to do all these things. It is kind of a means to an end when you become a business and move from a passion and hobby to an actual for-profit business owner. You do have to alert your state you're in business. You do have to alert your county sometimes with permitting and licensing issues. And then you do have to alert the IRS that you're making some type of income as a business owner. So they are necessities. They are absolutes that you have to do in your business. And the main thing that I would just tell people is don't overcomplicate it. Go to your state's website. That's how you're going to file for an LLC. It's going to be pretty simple to do so online now. Basically, every state has jumped on the online board train with what happened last year. And many states were kind of like slow to the punch. You could file online. And then some of them you were like, no, you still have to do paper format. It was really annoying and super cumbersome and old school. But then last year, like they didn't have a choice. They couldn't be in person and they had to start doing LLC and business registration type of things online. So yes, you need to do that online through your state. And your state is where you're going to register your business. Just know that. And then you want to go to your county's website and kind of just reach out or look up what type of licenses and permits you may need. Some people forget that there's like at-home permitting licenses for business owners. Because of course, if you were a brick and mortar and you were opening a store, you have to get like a business license and it has to be monitored by your local county government and things like that. So you have to think about it in the same respect. Even though I'm not a brick and mortar, I am still working from home. What other licenses and permits may I need besides the LLC? So just check that out on your county website. And then your EIN and bank account, you're going to also need to get. So your tax ID number, you just want to go to irs.gov, G-O-V, and then click on, there's like probably a big blue button on the IRS website that says, get my EIN number, and you just fill it out. And in 5 minutes, they'll send you your employer identification number. So that's what you'll use to file taxes. It essentially is a social security number for your business. So you don't have to file as a sole proprietor anymore through your social security number. You would file as a sole proprietor or an LLC under your business tax ID number, which is your EIN. It's free to get, super simple. You can do that on your own. I promise you. You just there's 5 steps through the process and the IRS walks you through it on their website. And then once you have all those things done, you're going to probably need your business registration through the state and your tax ID number to get a business bank account. Just go to whatever bank that you work with. I'm sure they open business checking accounts for people. And you can, of course, decide if you want to go with a different bank, like pricing wise, and just see what are my minimum amounts I need to keep in my account? Is there kind of unlimited transactions as a business owner? Can I transfer unlimited amounts in and out of my account, as you're paying yourself right from your business account to your personal account? Those are all things to consider when you're kind of shopping around for your business bank account. I think lots of times, small local banks do great with opening business accounts, and they're very kind of low risk, high reward situations for you being a business owner. You don't have to keep very much in your business bank account. There's not a lot of penalties involved, those type of things. So yeah, those are the main steps. But like I said, in the show notes of this episode, I will make sure to link that freebie for you all. And they have links to all of these things. There's additional, of course, I said there's 10 steps in our freebie legal guide for you. And I know a lot of them involve like contracts and thinking of like business names and trademarking and just like additional steps that you may want to consider. But those are the biggies just to answer that question for you. Okay, this question was a little bit more in depth. It's going to be, I'm just going to answer it briefly. But this is regarding people who perform different services in different states. So this person said, I offer different services and some on location in the state that I am registered in. And also I perform services in various other states that is not technically my home state, quote unquote, they say. Is there something different I need to do since I am accessible to perform services all over the US? I plan on working towards making sure that my business is legally sound on the back end before I provide all of these services and start working in various areas of the country. So the easiest answer is you want to be your domestic LLC in your home state. So where you are domiciled, where you will be collecting like snail mail, and your principal place of business, quote unquote, legally speaking, that is what it's called. So that is going to be where you reside, probably where you have a home or where you technically live. Or for people who kind of live a digital nomadic lifestyle, that's going to be a little bit different. You're going to want to choose the state where you can receive mail on behalf of yourself as the agent of your business, or, you know, where you are from and where you oftentimes go back to, where your familial home is, things along those lines. So choose the state that's best for your LLC. Many business owners, like you guys probably have heard that Delaware is a really great state for businesses. Not necessarily for LLCs, but for corporations. Delaware has phenomenal corporation laws, and it's more heavily weighted towards the side of the corporations. So many corporations decide to like host their principal place of business in Delaware, and they will sign up as a Delaware Corp, and then they will kind of be foreign entities is what it's called in various other states. So do you need to actually file, if you are an LLC in a certain state, do you need to file as a foreign LLC working in other states? It depends. So it gets complicated because it depends where is the majority of your business coming in and out of. Are you going to probably be performing over 50% of your services in this other state? Then the likely answer is yes, you are going to need to register as a foreign LLC in that state. So you're going to be registered technically in 2 different states. Also, what is it worth to you? If you are above that threshold, yes, risk and liability wise, it would behoove you to file as a foreign entity in this other state. Say you're only doing like 5 to 10% of your services here, 5 to 10% there, so on and so forth. You likely don't need to file as a foreign entity in those states, and you probably don't have to pay taxes in those states as long as you're paying taxes in the state that you are actually domiciled in and registered with your LLC. But these are all questions that consistently change with the tax laws. And just make sure that you're talking with your CPA surrounding this as well, because this is not only a legal question, it's in tandem with a tax question as well. So you want to make sure you're doing what's best and registering appropriately so that if states need to monitor you paying sales tax and things like that on behalf of your clients, you have to be ready for those type of situations as well. I oftentimes tell people, if you are like a nomad, you are performing services in many different states, it would probably be best for you to just be a sole proprietor where you're not a registered LLC in any state. Get yourself some business insurance, and you're going to have probably complications with taxes, of course, and sales tax and state taxes if you're working in various areas of the country. But that would be a question to ask your CPA. But legally speaking, it would probably be best to not worry about
registering as an LLC, registering as foreign entities in various states. Just be a sole proprietor, work off as an arm and extension of your person and yourself, and file through your social security number. And then this is additional income through your Schedule C. So you are, of course, making additional income through this business that you're running as a sole proprietor. And then you just have some insurance to cover yourself from any like negligence or damage type of situations. So you can just get like standard general liability insurance for your business. Okay, last question. Good transition. Speaking of insurance, when it comes to insurance, I know venues want to be the holder of your certificate of liability. So they want to be added as like an additionally insured for that period of time. Super easy to do with any insurance provider. It's just a rider that they will issue. And so you just contact your insurance policy and they'll do that. But this person said, I had a venue that wanted me to put the catering company as the holder of my certificate of liability, but under the same address as the venue. They are two separate companies, and I am the wedding photographer. Okay, this is super interesting because I have no idea why a catering company would need to be the holder of your certificate of liability as a photographer. Of course, you're photographing at the venue, but I think this is getting a little bit too involved here. And I remember this question popping up in the group, and I was like, I think you need to ask them who they got this information from. If it was their attorney as the venue owner, ask to call the attorney and clarify why this is actually happening. To me, that sounds a little bit far-fetched that you would need to have this many people hold your certificate of liability. I have only heard of venues asking for event insurance on behalf of clients or having an additionally insured for a period of time under your certificate of liability. Of course, they should also have insurance. That's really key here is you want to make sure that they also are insured. And so you could ask them for like a copy of their declaration page of their insurance policy because you don't want to be the only one insured. And then you're also additionally insuring the venue, and like they have way more risks and liabilities involved when they're the actual venue. So don't do that scenario. But this person had a red flag come up when the venue asked them that. And I specifically responded in the group like, this seems like a red flag to me too. And you need to trust your gut instinct with those type of things. Like start researching, asking the venue for more information. Why? Ask that question. And then say, can I speak to your attorney if you are represented by an attorney so I can clarify why this is needed and how this kind of imputes my liability too. So that is how I would answer that question. You guys, I could probably answer legal questions all day, every day. I love legal Q&As, but I am not going to put you through that. If you guys do have additional questions though, like I said at the beginning of the episode, please go to the Legal Paige community on Facebook. If you just go to the search bar and you type in the Legal Paige, Paige community, you will see our community pop up, and then you have to request to join. I just have a couple questions. I got to make sure that you're going to follow the rules of the group and that you are an actual business owner. And then you can jump in our group and ask any and all questions that you have. I am in there. My legal team is in there. We are constantly monitoring the group. People are very, very, very kind in our group. That is one of our rules is I don't like things to get political. I don't like personal opinions to come into play. This is strictly a legal group for business owners that is very, very like fact-based, and these are the legal steps you should take. People are kind. We're all colleagues together working towards being better back-end business owners. And so I highly suggest that you come join us. Like I said, go there. If you need to reach out to me in other forms as well, you can do so. You can send me an email. You can shoot me a DM and I will point you in the right direction. Have a great one, my friends. See you guys next week on the Legal Paige podcast.
Thanks so much for listening to this episode of the Legal Paige podcast. See, I told you being legally legit isn't so scary. Be sure to visit thelegalpaige.com for all show notes. And it would be super awesome if you could head over to iTunes and leave a review. Last but not least, don't forget to join my free Facebook group for unlimited legal and biz Q&A. Chat soon, Legal Pagers.